So the first thing I want to say to you is, look, this is a really exciting time to be entering nursing and midwifery, and I want to wish you the very best of luck in your future endeavours as members of the profession. I'm a nurse myself, and the opportunities that will present themselves for you to have an impact in terms of the patients and in terms of the services you will enter and the life that you will develop as a registered nurse or registered midwife is truly exceptional, and the impact that you will make is truly exceptional. But I suppose we are, and this is the focus of my discussion, we are publicly regulated professionals pursuant to the Nurses and Midwives Act 2011. And it's important to remember that, because in the ultimate analysis, our ability to practice as a registered nurse and registered midwife is contingent on the maintenance of our license, which is granted by the state. And that license is granted by the state and is regulated by the state, because while we have the opportunity to make such extraordinary differences in the lives of people, we also can make extraordinarily negative differences if the powers and privileges that are given to a registered nurse are misused. But the reality is of public regulation that ultimately the processes that adjudicate upon whether or not you can retain your license, if there is a complaint against you in relation to your professional practice, are mediated through the fitness to practice procedures of the Nursing and Midwifery Board of Ireland. So your first primary engagement with them will be registering, and if one is lucky, one will never engage with them again, save to re-register or to advance your registrations as you take on further registrations in your practice. But every year, my office represents a good number of nurses and midwives who are the subject of a complaint in relation to their fitness to practice. And the process that they undergo when they're the subject of a complaint is a legal process. And ultimately, if there's a fitness to practice inquiry, that inquiry takes place in public. It's important to remember as well that one need not have done anything wrong to be the subject of a complaint. And indeed, about 75% of the members that we represent every year, we manage to stop complaints against these people which are made to the Nursing and Midwifery Board at the preliminary process, because there isn't sufficient cause. But in order to properly defend yourself before the preliminary processes of the NMBI, and indeed before the ultimate fitness to practice inquiry, you do require expert legal advice and professional assistance. And it is a costly process. Now, membership of the INMO covers this cost, but in reality, to defend oneself with legal representation before the preliminary committee would cost one between 5,000 and 10,000 euro for a simple case. And in fitness to practice inquiries, you're looking at a bill for legal defence, because it is a tribunal with the powers of the High Court, of something between 15,000 euro and 80,000 euro. And this is not monies that people have, ordinary working people have available to them. And that's an inherent benefit of membership of our organisation. And I say that, and it appears like a sales pitch, but the reality is that every year I have people who come to my office who have not been members of the INMO and who come seeking to join the INMO in order to be defended. And we're not able to do that because we have to use the money from our members to defend our members and not to defend people who haven't been members who then later seek defence. So you do need to remember, in terms of your membership of the INMO and your professional practice, to what extent are you protecting yourself, and to what extent does that membership protect you in the event that you face a complaint that could remove your license and thus remove your livelihood? There's also it's important to bear in mind that there have been and are an increasing number of complaints to the Nursing and Midwifery Board about nurses and midwives. That isn't indicative of increasing levels of misconduct among the profession. It's indicative of the public regulation that takes place and the fact that people are judged before a tribunal that's reported on by the papers and the news, and consequently the public are more aware of it, and consequently there are an increasing number of complaints. Now, we provide a full service representation before the fitness to practice processes of the NMBI, which includes from the moment of complaint right up to the end of the fitness to practice inquiry, and we successfully defend many members every year before that process. But in terms of the time that I have with you, as well as just talking to you about the importance of membership in terms of professional protection, it's also important to reflect on whether or not and to what extent you can contribute to your own personal protection and important things to remember in the context of your practice. So there are three main areas that I'm going to talk to you about. One is about statements that you might be asked to provide in relation to your professional practice. The other is around your notes of care, and the third is around the duty to raise concerns where you believe that there's something might prejudicially affect the safety or welfare of a patient. Statements are important because any time that you're asked as a professional to provide a written account of your professional practice in relation to any matter, whether that's an interaction with a colleague, whether it's the type of care provided in relation to a resident or service user or patient, or whether it's in the context of somebody having passed away, for example, or the coroner's court, expert representation is required at the earliest stage when you are making a statement, because the key facet to remember when making a statement is that a statement can be made today in a particular context. For example, a patient makes a complaint. That patient might make a complaint to the hospital, the HSE, they may make a complaint to your service USA, they may then make a complaint to the NMBI, they could make a complaint to the Gardaí, they could make a complaint to HICWA, they could make a complaint elsewhere, and litigation could ensue as well. And the statement that you make following a request from a manager, for example, in your employment, can then end up being used in all those processes, and we call that the multiple use of statements doctrine. And consequently, you should, at any time that you're asked to make a statement, and that means to make a formal note of your conduct or performance in writing, outside your notes of care, you should be alert to the fact that this is an important moment in professional practice, and one where you should seek advice from your professional association in the form of the INMO. And we will advise in relation to the content of a statement, we'll advise in relation to the format of it, and we'll advise you in relation to disposing yourself in the best possible way as a professional and defending your interest. You should never make a statement in relation to any matter until you have had an opportunity to have advice in relation to the content of that statement. You should also never make a statement in a rush, and you should never ultimately be satisfied when somebody says to you, oh, just write that down quickly and it'll be okay, because that person may believe what they're saying to you, but they can't represent that to you. And still to this day, I encounter people who have made statements coming off night duty. They've written it down on an A4 pad and handed it in. And that's not the way you want to professionally dispose yourself. If you're going to submit a statement as a registered professional in relation to something regarding your conduct or your involvement in a matter, it should be typed, it should be formatted, it should contain the right information, and you should have professional advice in relation to it. In terms of providing a statement and some general principles to bear in mind in that regard, any statement you provide in relation to any matter, and it is quite common for professionals to be asked about statements because a complaint, or to make a statement because a complaint has been made, because the management have a concern in relation to the type of care that was provided, or there can be a range of other circumstances. Most statements should be relatively brief. They should be factual and they should be chronological. And we're not trained as professionals to write statements, and that's why the people in the INMO who are trained will provide you with advice in relation to that which you have written yourself. You are not required to make a statement on demand, and your management have a right to ask you for a statement, and it's a reasonable and lawful instruction to direct you to provide a statement, and you are obliged to provide it, but you are not obliged to provide it on demand. Never provide it when you're just going off duty, and submit it. Always take time and always have it reviewed. You also have the right to know why you are being asked for a statement. What is the context in which you are being asked to provide this statement? Is it as a result of a complaint? Is it as a result of a concern your manager has? And you also have a right to know who is requesting the statement from you ultimately. So is your employer asking for themselves? Are they asking for the coroner? Are they asking for the employer's solicitor in terms of litigation against the employer? And these are important things to remember. You're also entitled, before you write a statement, to have access to any relevant records regarding the matter in question. So for example, I couldn't tell you who I met last Tuesday without looking at my diary and looking at the notes of what I discussed with them, because you meet so many people. And so it will be for you in terms of the frequency of changeover of patients, resident service users, the volume of them you will meet. So it's always really important to review records, and you have a right to review those records and any incident form, for example, you might have prepared or otherwise prior to making a statement. And it's very important to always read your clinical notes if you're providing a statement in relation to the clinical care. It's also important to remember that some key things when you're putting down a version of events for yourself, you maintain your information as factual, what you did, what you saw, and you don't really offer opinions. It's about what happened, when it happened, where it happened, who was involved, what you did, what other people did, and if you told anyone else about it, to include that as well. It's important to dispose yourself as well as you would like to be understood and like to be seen. When you write a document, you are representing yourself as a professional. So you should be happy that it portrays you as the type of person that you are and your best self. And to do that, we use appropriate language. We ensure that it's structured correctly. We ensure that the points I made about brevity, factual content, and proper structure are included in the document. But we avoid things like emotive language and personal opinions. We stick to the facts and we stick to our professional assessment of matters. And always in a statement should be set out in a chronological order, and that's very important because it shows an organized mind and you're helping the reader to understand what happened. And again, as I've said to you, you prepare a draft and you always seek INMO advice. So the key takes from this in terms of statement, it is an important moment in a professional's life to be asked to provide a written account of one's conduct or involvement in a matter. You are always entitled to time, you are always entitled to information, you are always entitled to access advice, and you should always seek advice prior to submitting a statement. The next thing that I would just focus on is your notes of care. You will have, in the course of your professional education and training and in relation to your academic instruction, received on multiple occasions information in relation to the importance of the notes of care, whether that be from the perspective of the patient, whether it be from the perspective of the clinical team, or whether it be from the perspective of the profession. And it is important to remember that the NMBI code and the NMBI guidance on records tells us that the notes of care are a representation of our professional practice, and poor recording of care and care matters remains a significant problem where registrants appear ultimately before the Fitness to Practice Committee. It is essential to have an adequate record of care. There can be pressures and time can be pressuring, but adequate notes of care are one's best defense when one is called upon to answer for one's practice. And remember, one may not be called upon to answer a concern until some remove from the matters of concern themselves, so some time can elapse, and your notes of care become ever more essential then, because your recollection fades, and where your notes are poor, then that is a representation potentially of poor practice. It's important to follow the NMBI guidance in relation to the format, content and style of your notes of care. It's important that if you're making a late entry, that you identify that it's a late entry and the appropriate way in accordance with the NMBI guidance. And it's important as well, if you're making a correction, that you make a correction in the appropriate way with the line not obliterating and the signature and date, etc. If you're making a correction. And these matters are exceptionally important, and they are, again, I just want to focus, the notes are a representation of the type of professional practice that you're engaged in. And I just want to offer a personal reflection as well. There are standard notes that we make, and then there are times that we are pressured and don't get to make the notes that we want, and then there are times that we have a concern about a situation. So you have your standard notes, and your aim is to ensure that they are a good representation of your professional practice. I'll give you an example as well. There could be pressured times. For example, you're allocated to an emergency department. There's a very unusually high number of attendances. You just are focused totally on clinical care and your notes are not what you'd like them to be. You're entitled to make a notation, for example, that you are under pressure, and you wouldn't use those words, but you would, for example, say that you were in difficulty and that you, for example, if care was delayed, you would note that down in your notes to ensure that there's an adequate representation of that. The final thing then is, if something seems unusual to you, we have a great intuitive sense as nurses and midwives, and if something seems unusual to you on a given day, then you should make an additional note or write or be conscious of writing adequately about that situation in order to protect yourself. And the final issue I'll raise very briefly is that we have, under the Code of Conduct, a duty as registered nurses and registered midwives to raise issues of concern in our employment, either using risk management forms, direct verbal raising of them, or the INMO statement of concern form. That is not a curmudgeonly behaviour. It is a professional obligation. It serves two purposes. First and foremost, it serves the purposes of raising issues of safety to protect patients and service users. And secondly, things can happen because there are concerning circumstances such as low staffing, poor skills mix, high demand, inadequate time, etc. And having a record of raising them can also be of assistance in defending you. So look, I'm afraid I'm like the harbinger of doom talking to people. The vast majority of you will never meet me. But the point is that in order to protect your license, to ensure that you can defend yourself and maintain your license and maintain your livelihood, it's important to be a member of our organisation so that we can defend you. And some of the reflections I hope I've offered you give you some food for thought in relation to things that you can bear in mind in your daily practice to protect yourself to the maximum extent possible. But I leave you with the message of it being an excellent time to be a nurse and midwife. The advancements in our profession are extraordinary. You will be a huge part of that, and I wish you the very best for the future.